Hi everyone, Harry here, coming to you from the Pittsburgh airport. You'll hear the muzak perhaps in the background to talk about the Supreme Court's granting review with the likelihood, since it granted review, of reversing a law in Colorado that basically says you cannot try to have therapy aimed at changing the perceived sexual orientation of a child or aimed at preventing a child with gender dysphoria, feeling that they want to be another sex, from doing so. And the challenge here is to the law. There are similar laws in about 20 states, and they are based on findings that it can be very harmful to children in particular, either to try to change their sexual orientation or even more so, to keep them from acting on gender dysphoria, because if they don't act on it during puberty, they have ahead of them potentially a lifetime of discontent with their gender that is associated with all kinds of terrible outcomes, including suicide. So Colorado comes in and says, hey, licensed therapists, don't try to persuade people to who believe that they are homosexuals, that they shouldn't be. Don't try to persuade people who believe that they're in the wrong gender, that they shouldn't pursue that point. And the lawsuit is brought by a Christian therapist, a sort of social worker, and as she explains, she wants to be able to offer patients who come to her on a voluntary basis, and I think it's pretty clear reading between the lines, she wants to be able to give them religious-based therapy, which says, in the case of sexual orientation, I don't want to be too crass or inaccurate, but to give you the idea, counseling that says, hey, you should, as the Christian precepts counsel, not be homosexual, and hey, you should accept your birth sex, whatever it is, notwithstanding your feelings of dysphoria. Colorado says you can't do that, and she has brought a challenge based on the First Amendment. She says having that regulation in place, which says you can counsel in a certain way but not in another, violates her own First Amendment speech and free exercise rights. Now, the court had an opinion saying much the same thing a couple years ago, and they declined to take up the issue over the dissents of Justices Alito and Thomas. And it stands to reason from Thomas and Alito's other positions that they believe that the state should not be able to keep religious-based counselors from counseling based on their religious views, that, hey, you shouldn't become, if you can, you should fight against becoming gay, and hey, you should accept the gender that you received at birth. So that the court has now taken the case seems to me a very strong indication that they are looking to reverse the holding that upheld the Colorado prohibition. The way that was upheld, and how it generally has been upheld here by the 10th Circuit, the federal appeals court that sits over the Denver or Colorado trial courts, is that this was a prohibition on conduct, not speech. A certain kind of conduct by that Colorado is singling out, and therefore not subject to the highest scrutiny under the law, which would be if the state were censoring the words or the counseling based on the viewpoint or the content of it. So she wants to say, and I think she has sympathy in the court, does the petitioner here, and the court has said, we're going to take the case. Hey, you're telling me I can't counsel them, and I'm a Christian, I would counsel them in the way that I've said, but because I have that viewpoint, I'm not allowed to do it. There's also things in the Colorado law having to do with level of professionalism and the like, but she is not, she's more of an informal, voluntary therapist, but she is saying, these are my personal views, and because of those personal views, you say I cannot counsel Colorado youth. That's wrong. First, it's wrong for the 10th Circuit to say it's conduct, not speech. It's really speech. And then second, being speech, it's unconstitutional for Colorado to say you may not do it because we don't like that particular speech viewpoint. We don't. And Colorado did act, and their attorney general has said in urging the court unsuccessfully not to take the case. There's all kinds of evidence that when young people are urged against adopting homosexual orientation, or even more so because it's time sensitive, undertaking therapy as pubescents before they become biological adults, and therefore preventing any possibility of changing their gender, that leads to all kinds of terrible outcomes. So acting on that basis, Colorado said, don't come in here, and we want to protect our children, and we don't want religious views being pushed on them in a way that could lead to all kinds of bad health outcomes. Look at these 99 things that are in the record for the actual order to support the Colorado distinction. Okay, so that is the distinction, and they say it's content, not speech. So the challenger says, A, it's speech, and B, it discriminates both on the content, so a pure First Amendment, but also based on its religious character and identity, so therefore a discrimination against free exercise. And given the interest the two members of the court showed before, and given that there are now four, I think it is quite likely that four members of the court are ready to reverse the 10th Circuit, and my best guess is that the rest of those four are acting strategically and concluding that, as the court has done in a series of cases in recent years, they are going to recognize a right of free exercise that cannot be. It's not a matter of whether it might be permitted, this kind of counseling. It's that it may not be prohibited based on what they're saying is its religious content. I think the court is going to say that the First Amendment rights of speakers, including religious speakers, and their additional free exercise rights means that the state can't tell them not to counsel young people in certain ways, even based on a rich record that the counseling in those directions leads to bad outcomes, is as bad for the young people in question. So, court's now taken this case. There'll be regular briefing and argument on it, and I think you can look for an opinion, possibly not until next term, but likely saying, Colorado, you may not do this, and you can't pass a law that tells religious people they can't counsel based on their honest beliefs in what should or shouldn't happen with people who are struggling with young people of sexual orientation or even more gender dysphoria. So that's what's happening with the issue under review. Is it speech? Is it content? And then is it a restriction based on content or viewpoint even, which is even higher up? That is to say, based on the notion that we don't want you coming in and telling them one particular thing, as in, do try to fight feelings of homosexuality, don't try to convert your gender based on religious sensibilities. Colorado says you can't do that. 10th Circuit says that's a conduct rather than a speech restriction. Supreme Court takes the case and will probably reverse, both saying it is speech and saying you cannot restrict the speech of religious folks in this way. So keep an eye out for what they'll do. Obviously, it fits in with a broader panoply of some of the social issues involving abortion and the like, and so it always is watched even more carefully there. But this will, in fact, dictate whether or not Colorado's preference for certain kinds, but not other kinds of counseling, will in fact remain, and my best guess is it will not. Talk to you later.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.